Hi, everybody, and welcome to our discussion of Chapter 15 in Management 422. In Chapter 15, we're going to be exploring issues related to the employee as a stakeholder. As always, please review our learning objectives for the week. In this week's lesson, we are going to endeavor to understand workers' rights to organize unions and bargain collectively. We're going to learn how government regulations assure occupational safety and health and what business must do to protect its workers. We're going to evaluate the limits of employers' duty to provide job security to their workers. We're going to analyze employer obligations to pay workers fairly and how pay policies can contribute to income inequality. We're going to be appraising the extent of employees' rights to privacy when business monitor employee communications, police romances, test for drugs or alcohol, or subject employees to honesty tests. And we're going to be looking at and debating if employees have a duty to blow the whistle on corporate misconduct, or if an employee should always be loyal to their employers. Employees, due to their direct relationship to the economic purpose of the entity, are primary or market stakeholders. The employer-employee relationships creates rights and obligations on both sides of the equation. Slide 4 provides a list of the rights and duties on the part of each. Employees have a right to organize and bargain collectively. That's constitutional in many states. They have a right to a safe and healthy workplace. They have a right to privacy. They have a duty to discipline fairly and justly. They have a right to blow the whistle. They have a right to equal employment opportunity. They have a right to be treated with respect for fundamental human rights. And they have a right to fair and decent wages. On the other hand, the employer has rights and duties as well. They have a right to have no drug or alcohol abuse on premises. They have a right to have employees not engage in actions that would endanger others. They have a right to have employees treat each other with respect without harassment of any kind. They have a right to have employees be honest and have, appropriate disclosure. There's a right to loyalty and commitment and respect for the employer's property and intellectual capital. Generally speaking, most would agree that employees should have the right to organize and bargain collectively, have a right to a safe and healthy workplace, have job security, and these do not always exist, and particularly where we've seen attacks on organized labor. Most recently in Missouri, we've seen things like the Right to Work bill pass, which again is viewed by many as very anti-worker or anti-labor. As noted, the role of labor unions has been diminished over the years. Pro-business laws have made it much more difficult to unionize and function as unions have traditionally functioned. We will see what this change in the balance of power does to wages and job security in the future. Unions overall have been declining and decreasing in their influence. As noted, however, despite that sort of trend line towards diminution of union power, there have been some small strides as set forth in slide 8. Worker safety has been enforced through governmental regulations and the courts. This slide depicts some of the acts and policies that have been put in place to protect worker safety. Job security has been problematic. Historically, in the absence of an employment contract, employment has been at will, meaning that an employee could be shown the door for any reason or no reason. Today, it is critical for HR professionals to document reasons for discharge and make a case as protected status may be raised, things such as age, gender, religion, etc. Employee rights seem to be diminishing, and the relationship between employee and employer seems to be more contentious than ever in many cases. Socially responsible entities should have strong bonds with their employees and treat them as the valuable resources that they are, rather than interchangeable, fungible commodities. The issue of the living wage is one that has been across the news lately. The issue of a living wage or increased minimum wage has really been at the forefront of our discussions in labor law. The jury is still out on the long-term impact of raising the minimum wage, but companies that value their employees both socially and economically generally attract and keep quality employees. Privacy in the workplace is another issue that has emerged. There are a number of workplace-related areas where this issue has raised its head, and we'll discuss some of these in this week's discussion. Electronic monitoring of employees' activities and information is also an issue. Generally, monitoring activity at work via phone, computers, email, and the like has been held to be acceptable, particularly when one balances the business interests against the right of the privacy of the employee, particularly when that monitoring is taking place on employer-provided phones, computers, and so forth. Romance in the workplace. The best advice that I can give is no, 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 although it happens. Each company should have very specific policies in its policies and procedures manual to address circumstances wherein this might be permissible. It should never be allowed between supervisors and subordinates due to concerns of sexual harassment. Drug testing is another issue with controversy and litigation. Most employers require a pre-employment drug screen. Not many issues here. If an employee has an accident at work or comes into work behaving consistently with being intoxicated, that's another situation where it might not be an issue to do a post-employment drug test. Random testing has become more problematic, but it has generally been allowed. Folks who suffer from alcohol abuse and other issues have been helped by employee assistance programs, and proactive companies should make this available to employees who are struggling with these issues. Polygraph testing. Because much of business loss is caused by employee theft and dishonesty, polygraph testing was employed pretty consistently a number of years ago. The Employee Polygraph Protection Act greatly curbed the use of polygraphs as an investigative tool in this context. Polygraphs are simply not that reliable in the first place, and the results continue to remain inadmissible in court. What about employees' rights to free speech in the workplace? Should employees be allowed to speak out against or speak negatively about their employers? Employees are generally entitled to free speech rights, but that can be balanced with the interest of the business and the employee's duty of loyalty. Whistleblowing, when an employee comes forward with claiming illegal activity on the part of the employer. This is encouraged, and under federal law, an attempt by the employer to crack down on such speech can be met with significant civil liability. The next slide that we look at, slide 21, summarizes the major pieces of legislation that deal with whistleblowing. Spend a little bit of time looking at these in your text. To justify whistleblowing or to protect a whistleblower, 4 conditions must be satisfied. The organization must be engaging in harmful or illegal behavior. The employee has tried to address the issue internally. Making the issue known would stop or prevent the harm from occurring, and the harm is serious enough to justify the costs of disclosure. When those 4 conditions are met, a good case for whistleblowing can be made. Employees should be treated as valuable stakeholders and not as necessary evils. When corporations have good, proactive relationships with their employees, the company generally flourishes. All right, well, that's all we're going to talk about in terms of Chapter 15 this week. In Chapter 16, in our next lecture, we're going to be looking at issues related to managing a diverse workforce. We'll talk with you then.